This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're talking about a chiropractor who had the unmitigated gall to sue a billing company to get her share of their fraudulent billing. And they filed the suit in the United States District Court only to find that she lacked standing and that the case was dismissed. Now, this case is a perfect example of Chutzpah, a Yiddish term that applies to unmitigated gall, because she attempted to use the federal court to obtain a share of the proceeds of fraudulent insurance claims. Tyanna Dodson is a chiropractor who sought compensation from ExamWorks L.L.C's medical billing and scheduling provider. Dodson alleged that ExamWorks overbilled her patients' insurers for her services to insurers for independent medical exams, IMEs, that she conducted. In Tyanna Dodson versus ExamWorks, the United States Court of Appeal for the Fifth Circuit on February 28, 2025, dealt with Dodson's contentions that the IME she conducted to help insurers defeat attempted insurance fraud was billed by ExamWorks fraudulently overcharging her insurance clients. She sued ExamWorks for half of the excessive billing and damages because she faced discipline and charges of insurance fraud. The district court found that she had no standing to bring the suit and ignored the fact that she sued in federal court to gain a share of the proceeds of a fraud. Dodson had entered into a contract with a company called Landmark Exams in 2015, which was later acquired by ExamWorks. She terminated her agreement with ExamWorks in 2018, more than 7 years ago, claiming mishandling of billing for over 80 IMEs she conducted in 2017 and 2018. Dodson sued ExamWorks for overbilling insurers and billing for services she did not perform, bringing claims for breach of contract, breach of fiduciary duty, constructive fraud, and declaratory judgment. She alleged injury from ExamWorks' failure to give her half of the allegedly ill-gotten gains and the risk of professional discipline and criminal liability. ExamWorks moved to dismiss Dodson's first amended complaint for lack of standing and for judgment on the pleadings. The district court dismissed the case. Dodson's appeal contended that the district court erroneously concluded she lacked standing and abused its discretion by denying her motion to amend the judgment. The Fifth Circuit reviewed the case and found that Dodson failed to demonstrate a sufficient injury in fact. Dodson's claims of harm from ExamWorks withholding her cut of proceeds from fraudulent billing and the risk of future civil and criminal liability were deemed insufficient, mainly because the statute of limitations had run. To satisfy Article 3 standing, the court noted, a plaintiff must show 1, she had suffered an injury in fact, 2, that the injury likely was caused or likely will be caused by the defendant, and 3, the injury is likely to be redressed by the requested judicial relief. Dodson presents a long list of purported injuries to the court, which essentially collapse into 2 For standing purposes, 1. ExamWorks withheld Dodson's cut of the proceeds from fraudulent billing, and 2. She now faces a risk of harm for potential claims and civil and criminal liability, because, of course, it is a crime in almost every state in the Union to commit or participate in an insurance fraud. For her cut of the purported ill-gotten gains, Dodson alleged that she suffered benefit of the bargain damages, since I guess she claimed that her bargain with ExamWorks included fraud. She stated that ExamWorks breached its contract when it fraudulently billed and overbilled for her IMEs and related services without providing her with the appropriate fees which she was entitled to as per the parties' contract. Dodson already received all the proceeds that she could legally receive under the contract with ExamWorks. Even if Dodson had suffered harm, it would not have been to a legally protected interest. To the extent that Dodson seeks to use federal courts to pursue her cut of allegedly illegally obtained funds does not suffice for a conclusion that there was Article 3 standing. ExamWorks observed to the court that the time bar eliminates Dodson's risk of any professional discipline related to her allegations, which all allegedly occurred in 2018 and before. Any risk of injury that Dodson faces from potential future actions by regulators is too speculative for Article 3 purposes. Because she has not pleaded sufficient injury for Article 3 standing, the Fifth Circuit affirmed the district court's dismissal of this case and its denial of Dodson's motion to alter the judgment. In my opinion, her actions were classic chutzpah, a Yiddish term that has found its way into the English language. It is defined as unmitigated gall and defined by the example of a person convicted of murdering his parents, who then seeks mercy from the court because he's an orphan. Dr. Dodson's claim for half of the illegally obtained fees by filing suit in the federal court is on his face not only a claim without standing, it is contumacious conduct, asking the court to issue an order to assist her in obtaining her share of fraudulent billing. I am only surprised in this case that the Fifth Circuit did not refer Dodson to the U.S. Attorney for prosecution. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you will also be able to access the more than 5,000 blog postings. You can also subscribe to these videos on YouTube and rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.